start with friends. The biodata of Deshpande sir is so interesting that I would prefer to read verbatim rather than cutting and all these things. So I'll read it verbatim. Chairman of Mumbai Panchayat, the largest voluntary consumer organization in India, Asia. See, every sentence you must have a look attention. Left his lucrative high position job in a multinational organization to dedicate himself for the cause of consumer protection. He practices consumer law only for consumers. He filed complaint against before NCDRC against LML company, if you remember the scooter deposit case, was successful in getting refund of scooter deposit for 4,22,000 consumers, aggregating to around 40 crores. That's a reason that I took the permission to read it verbatim. Every word is important. The very first amendment in the Consumer Protection Act was initiated by Mr. Deshpande to amend Section 14 with retrospective effect through urgent ordinance in 1991, and we saved thousands of judgments of district forums in country from being declared invalid due to some legal technicality. The entire historic LMS case filed by him prompted the NCDRC president to suggest to the government to amend the Consumer Protection Act to incorporate the provisions of class action in consumer protection. Class action is a very important factor, as we know. I think we will highlight while delivering this stuff. He filed complaints on behalf of 800 consumers against Jain Parajpe building in Consumer Court and succeeded in getting orders for refund of 24 crore. After long-drawn battle, mostly next month, all 800 consumers are expected to get their much-awaited refund of 24 crore rupees. He filed PIL on behalf of Mumbai Panchayat in High Court on 2 occasions for smooth and proper functioning of consumer forum courts in Maharashtra and secure orders, which have been getting better infrastructure, including proper places for district forum and state commissions. These facilities were not previously made available as was required. Sir, I understand that still a lot of more needs to be done. Advocacy Association. Sir, I welcome you to this forum as one of the consumers for whom we are helping all around. We welcome this loud applause.
Good morning.
Good morning.
And my apologies at the outset for being slightly late. Thanks to our services of Uber, Ola and all that on which we have to depend now. Firstly, let me thank Rotary Club and my friend C.A. Ramesh Prabhu for giving me this opportunity to be with you, to share with you the topic which is not only close to my heart, but which should be close to all of us. We are the consumers. No matter what you are today, somebody may be doctor, somebody may be CA, somebody may be advocate like my friend Sappal, anybody. Or you may be a child, you may be a teacher, you may be a parent. Whatever you are, one thing is certain, you are a consumer. It's an inescapable role that we have to play as a consumer. You have no choice. You are born as consumer, you are going to die as consumer. In between, you can be anybody. Choice is yours. You have a profession, you have your jobs, you have your business, whatever we have. But there is no escape from your being a consumer in your life. And if it is so, then you need to know how do I operate in this society as a consumer. You know, in economics, many of us must have learned and studied and might have been taught and told that consumer is a king. And when I say that, everybody has a sort of a mischievous smile on his face because everybody knows that, well, that remains in the book. You go on the street, who treats you as a king? No one treats you as a king. Actually, coming to think of it, It is because of you and me, mind you, it is because of you and me as consumer, the whole economy works. It is because you and me are there is a demand for production, there is a demand for services. And that is why there is a creation of production, there is a provisions of services. So you are a kingpin and you are really king. But frankly, who cares for you? Do they respect you that yes, because of you, the business exists? Because of you, the services exist? Because of you, the traders exist? That is the importance of the consumer, and still, we do not get that respect as a consumer as we should get it. And that is why the consumer movement. Why consumer movement? Is because we need to live a life where there is a respect, there is a dignity. You cannot be taken for granted, nor can you be taken for right as a consumer. But that is what often happens in your day-to-day life. And that is why it has been a sort of a demand over the last several years, pre-1986, that there should be one comprehensive legislation to protect and promote the interests of the consumers. And that is why, with the demand of a lot of consumer organizations, including of course Mumbai, Grahak, Panchayat, which is now completing almost 45 years this March 25th, or Gudi Padwa, will be completing 45 years. So it is because of the push and the demand and the urge that the Parliament passed Consumer Protection Act in 1986. And we have been living with this act for last all these years and even as of now. When this act was enacted, we as consumer activists enthusiastically welcomed this act as magic lamp, Aladdin's lamp, because it promised us that consumers will get justice for their grievances in say 90 days. And now, over a period of time, we see 90 days? No. 3 months, 5 months? No. 3 years? Possibly. Sometimes 5 years, sometimes 6 years, sometimes 10 years. The Consumer Protection Act 1986, which was enacted with the purpose of giving speedy redressal, simple redressal, expeditious redressal for the consumer grievances and the consumer disputes. Over a period of time, the trade has derailed. The other part of the Consumer Protection Act, the old act, was consumer courts, what we call popularly as a consumer courts. At the district level, there was a district forum. At the state level, there was a State Consumer Dispute Redressal Commission, in short, State Commission. And at the apex national level, it was called the National Consumer Dispute Redressal Commission, NCDRC, the National Commission. And it had a sort of a jurisdiction of district forum used to entertain complaints up to 20 lakhs rupees. State Commission, if it is more than 20 lakhs but up to 1 crore, go to the State Commission. And your claim is more than 1 crore, then go to the National Commission. That was the hierarchy. And the three-tier consumer dispute redressal mechanism was there. Now, as against that, now this new Consumer Protection Act, as I said, the old one had mainly two parts. One is the Consumer Protection Councils, which was recommendatory body, and the other is a dispute redressal mechanism or the agency, which is called the Consumer Courts. Now, the new act has added another chapter and another part, I will say, or another vertical, as we call it in the modern days. We have good styles of new words and all. So it is the three verticals now. One is the Consumer Protection Councils, the other is the Consumer Courts or the redressal mechanism agencies, and another one is the Central Consumer Protection Authority. that is the enforcing authority, which will now enforce the consumer rights, prevent the misuse, abuse or violation of the consumer rights, try to prohibit the unfair practices in the market and save you from the misleading and false advertising of which many a time you and I are victims. So this is the Consumer Protection Authority. The authority has the powers under the law to penalize, be that a trader, be that a manufacturer, be that a service provider, to penalize them if they resort to unfair practices, if they violate your rights, if they mislead you by way of advertisements and all that. So these are the three verticals. Consumer protection councils, they remain as they are, and I would rest them here only and not say much at this moment because it's not of a immediate or a direct concern to you and me. We only hope that they will perform better, and we all consumer activists and consumer bodies and also the media need to put pressure that that forum is made meaningful to deliver what is expected of them. Having said that, we come to consumer courts. Consumer courts, the major change that the new law has made is enhancing the jurisdiction, pecuniary jurisdiction of the consumer courts. Earlier, the district forum, now it is going to be called in the new act, commission, district commission. So there will be all commissions only. It will be district commission, state commission and a national commission. Now the district commission's jurisdiction, pecuniary jurisdiction has been enhanced from 20 lakhs rupees to 1 crore rupees. So the complaints for the value of up to 1 crore can be filed at the district level itself in the district commission. If your complaint is more than 1 crore but less than 10 crores, then you go to the state commission. And if it is more than 10 crores, then you go to the national commission. So this again the hierarchy remains the same, 3-tier, but the pecuniary jurisdiction has been increased. That the district commission will now have a jurisdiction right up to 1 crore. State 1 crore to 10 crores, and above 10 crores you go to national commission 10. Having said that, there is another major change made in the Consumer Protection Act. Earlier, the complaint was required to be filed after taking into consideration the pecuniary jurisdiction, what we call it as the territorial jurisdiction. And there, it is only you have to file the complaint in that district forum or the state commission where the opposite party resides or carries on the business, or where the cause of action arises. Now the new act adds to it. It is more consumer friendly, and it says that even where you are residing, no matter whether the cause of action arises there or not. Many times consumers faced a problem earlier that he has made some investment in some investment company with a registered office in Chennai or somewhere else. And you have to file a complaint. They say they are running a business and they have a registered office in Chennai. So you have to file a complaint there. So there is at the very beginning itself, there was a sort of a deterrent for the consumer to agitate his claim. And that is why, keeping in view this difficulty, the Parliament in its own wisdom has now said that consumer must have a right to file a complaint to the place where he is residing. So in a way it is a welcome step, and it brings justice closer to your door. So from that angle it needs to be welcome. Now having said this, the timelines again remain the same. 90 days or maximum up to 150 days, right? 3 months or 5 months. How are you going to deal with that? I don't see any solution, and there is no magic formula given either in the new act or in the rules that this will still ensure that. In fact, Parliament, while enacting this legislation, should have applied its mind as to how they are, when you put the wordings that as far, okay, you safely put it as far as possible, the complaint will be redressed in 90 days. How are you going to do it? Are you going to increase the number of commissions? There is no word about it. But there is a way out. This time, the new Consumer Protection Act provides for what is called as mediation. Now, while I welcome on one hand the process of mediation, which is a alternate dispute resolution mechanism, as globally it is known. On the other hand, I say it is the acknowledgement of the ground reality that consumer courts, that is the consumer commissions, even in future are not going to dispose of your complaints in the time frame of 90 days to 150 days, and hence the need for the mediation, which is a sort of a bypass given to you and a sort of a shortcut to your dispute redressal mechanism. And it is this, as I said, provides a way of hope. And for that purpose, you need to know what is this mediation. And I will just deal briefly on this. Mediation is a sort of an intervention by an independent, unbiased third party in your dispute. Then you will say then, what is the court doing? Court judge is also independent, unbiased and all that thing. But the courts are under the law and they are supposed to dispense with your complaint, adjudicate the complaint in the legal framework. And all my friends in the profession who are there, advocates, then you have been hearing a lot about RERA and MahaRERA. RERA is the name of the act and MahaRERA is the RERA which is being implemented in Maharashtra, because the RERA is supposed to be implemented by each state, and for that purpose the chairperson and all are to be appointed by the state governments. So each state has got its own, but the act is the central act implemented by the state. It's an independent autonomous body empowered with all the powers to regulate this sector. And now the three major players in the real estate are obviously the home buyers, consumers, the developers, promoters, whom we popularly or otherwise call it as builders, and then the real estate agents. So this sector regulates these three. So naturally, if you have any dispute with regard to against the builder or the promoter, you can definitely go to MahaRERA in Maharashtra. And then now there is a third door or the window that is open, and that is IBC, Insolvency and Bankruptcy Code, IBC. Insolvency and Bankruptcy Code, IBC, is a law, and for that the court is called the NCLT, National Company Law Tribunal. Okay. So now today, if a home buyer having paid anything more than 1 lakh rupees, 1 lakh is the threshold to knock the door of NCLT and the IBC, 1 lakh. So minimum 1 lakh claim you must have against the builder, and if he fails to refund you, suppose if you have booked 20 lakhs, paid 20 lakhs and booked a flat, he has not delivered, you want to have a refund, and builder says paisa nahi hai, market tight hai, बेचेगा तभी देखेगा. So you can go to even NCLT. Now the question comes, in a given set of circumstances, where should the person, now take the same example of having paid 20 lakhs, promised the flat in 2016 or 17, today we are in 2020, there is no sign of the project getting completed for another next 2 years. I am not ready to wait, I want my money back. Where do I go? That's it. Can you go to Consumer Court? New Act also? Yes, you can go. Can you go to MahaRERA? Yes, you can go. Can you go to IBC? Yes, you can go. So where should you go? Can I go to all three? No. You cannot ride 3 horses at a time. You also cannot ride 2 horses at a time. You cannot say that let me take a chance, whichever is earlier, I will take that and then close my other cases. So I will file simultaneously. Some consumers are really smart. So they ask us, why not we file all three and whichever comes first, I take that and then I will withdraw. No. At the time of filing itself, you should not have filed a case in any other court. RERA has a special provision in the Act which says that if your case is pending in a consumer court against a promoter, you can withdraw that with the permission of the bench and file it in the consumer court. There is of course a priority that at the time when the Act came into being, okay, that time if the complaint is pending, that is 1st May 2017, if the complaint you have already filed in the consumer court and that is pending and you know that is going to take another not less than 2 years or so, then why not go to MahaSeWA? Yes, make an application, withdraw that complaint, file it in MahaSeWA. So that time what you have filed, maybe you have filed a case in 2015, nothing is happening in the consumer court. So now you think that okay, MahaSeWA may provide me a speedy remedy. Yes. So that time will be not taken into consideration for the limitation purpose. The limitation under the Consumer Protection Act is 2 years. Interestingly, if you ask me what is the limitation under RERA, this is a very interesting thing. And if I say the limitation is 5 years, I should not be wrong. Okay, I just want to take so much so on that. Otherwise, in the law of limitation, civil law and all that thing, 3 years. So be that so. Now, so you have consumer court, you have MahaSeWA. In MahaSeWA, again I say option A and B. One is a traditional, go to the MahaSeWA bench. In that there are two things. One is there is an adjudicating officer, AO, who is supposed to deal with only complaints and the claims which fall under section 12, 14, 18 and 19. 12, 14, 18, 19. Simple. 12, 14, 18 and 19. If these are the complaints regarding some claims about the refund or the compensation and all that thing, so that goes before the AO or adjudicating officer. Any other complaint under MahaSeWA or RERA, that will go to RERA authority. That is the chairperson and the other members of the RERA. So that is that part of it. And as I said, another part under MahaSeWA, as I referred earlier to, you can go in a conciliation mode. Instead of going to AO or authority, you can opt for conciliation. When you file a complaint in MahaSeWA, the fee is 5,000 rupees. And when you go for conciliation, the fee is only 1,000 rupees. When you go to MahaSeWA, the proceedings are legal and very formal. Whereas you go to the conciliation, the proceedings are actually informal, more party friendly, and most important thing, we don't allow lawyers. We don't allow lawyers. For two simple reasons and good reasons. One is, this is a sort of an effort and a process for settlement of the disputes with compromising and a sense of understanding. You don't have to be too bright to show your legal eloquence, and hence you are not fighting your rights there. If you have to fight the rights, go to the courts, go to MahaSeWA, no problem. But you are coming for some settlement, okay, our conciliators will help. So it is an informal thing, and that is why this thing is informal. It is inexpensive, it is speedy, it is non-appealable. And that is why if we allow advocates, then they will again start technicalities of the law and they will frustrate the very process of conciliation. So with all due respect to my professional brothers, we say, sorry, lawyers not allowed. Maybe that is one of the reasons why we get a success rate of 80% and speedy, really speedy settlements in less than 2 months and maybe in less than 3 sittings, thanks to the absence of lawyers. And I have absolutely no fear or sort of what I would say, anything for, it's not a disrespect, but it's a matter of fact that the lawyer's profession, sometimes in their over enthusiasm or anxiety to do justice to my client, you do injustice to the other side also, where the justice is much needed. So that is the thing. So that comes to MahaSeWA's settlement under adjudicating officer, dispensation or conciliation. Now comes the IBC and ABCLT. Now look at the things. IBC originally did not give you a sort of a status or the right to file the case under NCLT. Sometimes I fear and find that this remedy that is provided under IBC is more disastrous, okay, than the disease itself. It should be a remedy. It should not kill the patient. It should cure the patient. Here you see what is the drastic provision in IBC under NCLT. The moment, suppose if one case of a consumer, home buyer, now home buyer is treated as on par with other creditors like bankers who have given loans and they have become NPA. The builder has not been able to repay their loans. So the bank can knock the door of IBC. Now one single consumer also, till recently. Now there is a amendment to that. Now when it comes to cost and benefit, again, consumer court, how long I have to wait? My learned friend Sampath will perhaps be able to enlighten me, but I can also tell you that, okay, be ready to wait for a long, as I have said earlier, Consumer Protection Act has been a failure. It has failed to deliver in a time span. So if you want rightful interest, maybe 12%, 15%, 18%, days of 18% have gone. So go to consumer court, but be ready for wait. Be ready to go into appeal against appeal, because now up to 1 crore is at the district level. So your journey is going to start right from district level, go to the state level, then to the national level, then wait for the Supreme Court. So if you are ready for all that, consumer court is a way out for you. What happens in MahaSeWA? Conciliation, as I said, if you go final settlement, and the question may arise, if by conciliation, suppose if the builder agrees to do certain things, and if it does not do, what happens? Now, the rules are being modified to give more teeth to these consent terms also, and they are being made enforceable as if it is a final decree. So we are putting pressure on MahaSeWA that failure to comply with the consent decree should be viewed seriously, and no more fresh hearings in the court of MahaSeWA or a bench by MahaSeWA, but it should be enforceable in law. So that is the thing. So MahaSeWA as of now, again, how is the hierarchy? If the MahaSeWA bench or the adjudicating officer decides your case as a home buyer or as a redevelopment rehab portion, that is another area, then the appeal lies before the appellate tribunal of RERA. Okay, then the first appeal. Is there a second appeal? The answer is yes, but strictly on the limited points. That is, if the issue raises a law point which needs the interpretation, then the High Court will entertain. Otherwise, if it is just a case of facts that I have paid something, I want money back, and the money has been ordered, no problem, then second appeal will not be entertained. So the chances of builder misusing this provision of second appeal are less as compared to Consumer Protection Act. Consumer Protection Act can jolly well go into this, and then first appeal, then second revision, then Supreme Court. The journey is there. So to that extent, yes, RERA is worth trying it. Now, having said that, I will also agree with what Vasant Prabhu said, that practically, although the law is good, the implementation and also the interpretation of the law, interpretation of RERA, needs to be more dynamic, needs to be more progressive, needs to be more keeping in mind the very object for which the Parliament has enacted RERA. And I may say, again with a fear of contradiction, that as of date, not all benches of MahaRERA are interpreting and implementing RERA in the letter and spirit that was meant by the Parliament. So under CPA now you are going to have mediation, under RERA you have a conciliation. So what is best is perhaps one of the two things. Try your luck. Conciliator on the RERA, she is present here, and you can have that so that there is something in the writing on your record. Thank you very much.